Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss from section number 51 to 53 of the Bharatiya Sakshya Adhiniyam 2023.
Today, we're diving into a really crucial concept for any law aspirant, judicial notice. We'll be looking at it through the lens of Section 51 of the new Bharatiya Sakshya Adhiniyam 2023. Now, this is an absolute must-know for your judiciary and APO exams, so let's jump right in and break it all down.
Okay, so let's kick things off with a simple question to get our minds working. Imagine you're in court. Would you need to bring evidence, like a map or a government document, to prove that New Delhi is the capital of India? Well, the answer is, of course, no. And the legal reason why that is, well, that's the very core of what we're going to unpack today, the doctrine of judicial notice.
So here's our game plan for today. We'll start with a quick introduction to Section 51, and then we'll really deconstruct what judicial notice actually means. After that, we'll see how it works in practice with some great examples, connect it to some wider legal principles, and then we'll wrap up with key takeaways specifically for your exams. Now, in any legal proceeding, the rule is pretty simple. If you make a claim, you've got to prove it with evidence. But what about facts that are just so obvious, so universally known, that trying to prove them would be a complete waste of the court's precious time? Well, that is precisely where Section 51 comes in. It creates this super important exception to make the whole judicial process way more efficient. Let's look at the exact wording from the BEAR Act. It's very straightforward. Section 51 says, no fact of which the court will take judicial notice need be proved. So in simple language, इसका मतलब है कि अगर court किसी fact को officially recognize कर सकता है on its own without needing any formal proof, then nobody has to prove it. The court just accepts it as true. Simple as that. So the real question then is, what exactly is this power of judicial notice? To really understand how this section works in the real world, we need to break it down into its most important parts. Okay, on this slide, there are two key terms that you absolutely have to understand. First up, judicial notice itself. This is the action, right? It's the power the court has to just accept certain facts without making someone bring in a stack of papers. And second, we have a judicially noticeable fact. This is the kind of fact we're talking about, something that's either known by everyone, like the sun rises in the east, or something that's officially recognized, like a national holiday.
So how does a court actually use this power? Well, it follows a very logical three-step process. First, the court looks at a fact and decides, hey, is this something that's judicially noticeable? Second, if the answer is yes, it uses its authority to officially take notice of that fact. And third, the moment the court does that, boom, the requirement to produce any evidence for that fact just vanishes. Theory is great, but how does this actually work in a real courtroom? Let's connect these ideas to some practical examples and landmark case law to see how judicial notice is applied every single day. Okay, let's take a really practical example. Imagine there's a contract dispute and a deadline was missed. One side argues that the deadline fell on Diwali. Now, in this situation, they don't need to bring in a calendar or a government circular to prove that Diwali is a national holiday. The court will simply take judicial notice of this well-known and officially recognized fact. It saves everyone a lot of time. Now, this is a key case you should definitely know. In State of West Bengal versus Mir Muhammad Omar, the Supreme Court really cemented this doctrine. It held that courts have the power to take judicial notice of facts that are so universally known that they are beyond any reasonable dispute. This judgment is basically the bedrock that reinforces Section 51. And here's another important one. In Ankar Nath Singh versus the state of UP, the Supreme Court clarified that courts can, and really should, take judicial notice of public laws and official government acts. What does that mean for you? It means you don't have to present evidence in court to prove that an act of parliament actually exists. The court already knows it does.
To really get a firm grip on Section 51, it's super helpful to connect it to some bigger legal principles and also understand where it came from. This gives you a much deeper context and a more complete picture of the whole concept.
This entire principle is related to a classic legal maxim, actare incumbent probatio. It just means that the burden of proof is on the person who asserts a fact. This is a fundamental rule of evidence law. But Section 51, well, it's a huge exception. For facts that the court takes judicial notice of, the whole question of who has the burden of proof just doesn't even come up.
Now, for everyone preparing for exams, this is absolutely vital. You need to know the history of this provision. This exact same principle used to be in Section 56 of the old Indian Evidence Act of 1872. Now it's Section 51 of the Bharatiya Sakshya Adhiniyam 2023, and the key thing to remember here is that the law itself hasn't changed, it's just a renumbering of the section.
All right, let's switch gears and focus specifically on what you need to know for your exams. How can you take all this information and use it to score well, whether you're sitting for Judiciary or the APO exams?
For your prelims, you can definitely expect direct section-based questions. They'll probably ask about Section 51 of the BSA or its old number, Section 56 of the IEA. For your mains, a short note on the doctrine of judicial notice is a very high probability question, so be ready for that. And finally, you might get problem-based questions where they give you a scenario and ask you to point out which facts the court can take judicial notice of.
So, let's do one last quick revision. If you take away anything from this, let it be these three things. First, the new section number, Section 51 of the BSA. Second, the core concept. Certain obvious and official facts don't need to be proved in court. And third, the old law provision, Section 56 of the Indian Evidence Act. If you've got these 3 points locked in, you have a really solid handle on this topic. And that wraps up our detailed explainer on Section 51. The doctrine of judicial notice is, without a doubt, a cornerstone of evidence law, designed to make our justice system more efficient. For more Judiciary, APO, and other law exam-focused content like this, make sure you stay connected with us here at Ganga Education.
Today, we're diving deep into a really interesting topic, Section 52 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about the concept of judicial notice. And let me tell you, if you're preparing for the Judiciary or APO exams, this one is absolutely crucial. So let's get right into it, shall we? All right, so here's our game plan for today. First up, we're going to break down what judicial notice actually is. Then we'll get into the nitty-gritty of Section 52 and its mandatory list. After that, we'll see how this all plays out in a real courtroom, look at some key case laws, and even compare it to the old law. And of course, we'll wrap things up with some sharp exam tips and a super quick revision to make sure it all sticks. Okay, so first things first, we need to build a strong foundation, right? Before we jump into the details of Section 52, it's super important that you have a crystal clear understanding of what we even mean by judicial notice and, why it even exists in the first place. Think about it like this. Normally, in a courtroom, if you say something is a fact, you've got to prove it with evidence, right? That's the basic rule. But judicial notice is a huge exception to that rule. It's this cool principle that allows a court to just accept certain facts as true without needing a single piece of evidence. We're talking about things that are super well known, just obvious, or officially on the record. So you might be asking, why do we have this rule? Well, the purpose here is really practical. It's all about making our judicial system more efficient. I mean, can you imagine having to prove in court that New Delhi is the capital of India? It would be a total waste of time, wouldn't it? This rule avoids that kind of unnecessary work and helps speed up the process of justice. And that brings us right to the heart of today's session, Section 52. What this section does is lay out a very specific list of facts that a court must notice. And pay close attention to that word shall. It's the key here. It tells us that this isn't optional for the court. It's a command. Let's look at the actual text from the BEAR Act. It says, the court shall take judicial notice of the following facts. What does that really mean in simple language? It means the court has zero choice, no discretion. If a fact is on that list in Section 52, the judge has to accept it as true. No proof needed. It's not a suggestion, it's a direct order. Now, Section 52 has a pretty long list, but for your exams, you don't need to memorize every single word. Just focus on the key categories. For instance, the court has to recognize all the laws that are in force in India. Same goes for things like international treaties India has signed, what happens in Parliament, and the official seals of courts. Even things like the national flag of a recognized country or a public holiday listed in the Gazette, all of these fall into this rule. The court just knows them. Let's zoom in on a few key phrases here, because the wording is everything. First, that phrase, shall take judicial notice. We've talked about it, but let's be clear. This means it's a mandatory duty. No ifs, ands, or buts. Second, when the law says laws in force, it's not just talking about the big acts from Parliament. It covers everything, including delegated legislation. And finally, you'll see the term appropriate books. This just means that if the judge is ever unsure, they can just look it up in an official book or document to confirm. Okay, so we've got the theory down. But how does this actually work in a real courtroom? Let's move from the textbook to the practical. What does a judge actually do when this situation comes up? Honestly, the process is super simple. It's just a 3-step check. First, someone presents a fact in court. Then, the judge does a quick mental check. Is this fact on the list in Section 52? And finally, the decision. If it's on the list, boom, the court accepts it, no proof needed. If it's not on the list, well, then the party has to bring in evidence to prove it. Simple as that. Let's make this real with a quick example. It'll help you see exactly how this works. So just picture a typical courtroom scene. Imagine there's a dispute over a contract. One lawyer stands up and refers to a section in the Indian Contract Act of 1872. Now, can the other lawyer jump up and say, objection, you have to prove that this act even exists? Absolutely not. Why? Because, as we know, all laws in force in India are on the Section 52 list. The court must take judicial notice of it. The key takeaway here? Its existence doesn't need to be proven. Period. You know, to really get a feel for any law, you can't just read the bare act. You have to see how the courts have interpreted it over the years. That's where case law comes in. So let's look at a landmark case that really shines a light on this rule. In the major case of State of West Bengal versus Mir Muhammad Amar, the Supreme Court really nailed this down. The court basically said that judges can and should take judicial notice of facts that are so famous or obvious that trying to prove them would be a complete waste of everyone's time. This case perfectly captures the whole spirit of Section 52. There's a foundational legal maxim in evidence law that goes, actori incumbit probatio. It's a fancy way of saying that whoever makes a claim has the burden of proving it. But Section 52? It's a massive exception to this rule. For the facts on its list, it completely lifts that burden of proof. You don't have to prove it because the court already knows it. Okay, let's tackle a question that is almost guaranteed to pop up in your exams, especially with the new laws. What's changed between the old law and the new one on this topic? Let's do a quick comparison. Under the old Indian Evidence Act, this rule was in Section 57. Now, under the new Bharatiya Sakshya Adhiniyam, it's Section 52. Here's the most important thing you need to remember for your exams. Nothing has really changed except the number. The core principle, the list of facts, it's all the same. This means all the old case law under Section 57 is still perfectly valid and relevant. Let me clear up a common point of confusion right now. Does this section have any punishment attached to it? The answer is a big, fat no. You have to remember, Section 52 is just a rule of procedure. It's about how evidence is handled. It doesn't create a crime, so naturally, there's no punishment involved. All right, let's shift gears and focus on what matters most to you, passing your exams. So for all you judiciary and APO aspirants out there, what are the absolute must-know, can't-forget takeaways from Section 52? Okay, listen up. For your prelims, be ready for direct questions. They might ask for the section number straight up, that's Section 52, or they'll give you a fact, like the national flag, and ask if it's judicially noticeable. For your mains, you're likely to see either a short note question on judicial notice or a problem-based question where you have to apply Section 52 to a given situation. All right, time for a super fast recap. If you remember nothing else, remember these 3 things. 1. The section number is 52 of the Bharatiya Sakshya Adhiniyam. 2. The core concept is the court's mandatory duty to accept certain facts without any proof. And 3. Its exam importance is extremely high. You need this for both prelims and mains. Got it? And that's a wrap for today's explainer. But before you go, I've got a little brain teaser for you to test what you've learned. The question is, can a court refuse to take judicial notice of a fact listed in Section 52? Tell me why or why not. Drop your answers in the comments below. I'd love to see what you think. For more content like this, designed to help you ace your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're going to break down Section 53 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section deals with a really fundamental principle, the idea that facts which are admitted don't need to be proven. It's an absolutely critical topic for your judiciary and APO exams, so let's dive right in.
So here's a quick look at what we'll be covering today. First, we'll get a solid understanding of the core principle behind Section 53. Then, we'll break it down into its key ingredients. After that, we'll see how it works with a practical example, look at some important judgments and maxims, compare it with the old law, and finally, I'll give you some solid tips to help you ace this topic in your exams.
All right, let's start with the big idea behind this section. At its very core, Section 53 is all about judicial efficiency. You know, The court's time is an incredibly valuable resource, and this rule makes sure it isn't wasted on proving things that both sides already agree on.
The core principle is simple, but it's really powerful. Facts that are admitted don't need to be proved. You see, when a party formally admits to a fact, that admission is considered one of the strongest pieces of evidence against them. This helps streamline the whole legal process and allows the court to focus its energy on the real issues that are actually in dispute.
The language of the Act itself is very straightforward. In simple terms, what this means is that in any legal case, if the parties involved or their agents agree to admit a certain fact, then there's no need to present separate evidence to prove that fact. This, of course, saves a huge amount of time and effort for everyone.
Now let's peel back the layers a bit. To really master Section 53 for your exams, you have to understand its essential components, or what I call its key ingredients. So let's break them down.
There are 5 critical elements that come together to form a proper admission under Section 53. Getting a handle on these 5 points will give you complete clarity on how and when this important rule of evidence is applied.
Okay, let's examine these 5 ingredients. First up, the admission must be made by the parties in the case or by their authorized agents. Second, an admission can happen at the hearing. That means an oral admission made right there in open court. Third, it can also be made in writing before the hearing, like in pleadings or affidavits. Fourth is admission by pleadings. Now, under civil procedure rules, if one party states a fact and the other party doesn't specifically deny it, it's considered admitted. And finally, and this is a crucial point to remember, the discretion of the court. Even if a fact has been admitted, the court can still ask for proof if it finds the admission doubtful or believes that further evidence is necessary in the interest of justice.
So, we've gone through the theory. Now let's look at a practical example to see how Section 53 actually operates in a real-world courtroom. I think this will make the concept absolutely crystal clear for you.
Let's think about a very common situation, a civil case that involves a dispute over a contract. How does Section 53 come into play here?
Okay, in this scenario, A files a case against B for breach of contract. In his formal reply, which is called a written statement, B says, yes, I did sign the contract, but he denies that he broke any of its terms. Right there, B's statement that he signed the contract is a formal admission. So, because of Section 53, A no longer has the burden of proving that B signed the contract. The court can now get straight to the real point of contention. Was the contract actually breached? This is a perfect illustration of how the section saves valuable judicial time.
To really appreciate the legal weight of admissions, it's so important to see how our higher courts, especially the Supreme Court, have interpreted this principle. Case law and these foundational legal maxims provide the framework for how this section is applied.
In the landmark case of Nagindis Ramdas versus Dalpat Ram Icharim, the Supreme Court held that admissions made in pleadings are binding on the party who makes them. The court really emphasized that such admissions are considered the best and strongest form of evidence against that party. This is a key case, and you should definitely remember it for your exams.
This entire principle can also be understood through a well-known legal maxim. The maxim, confessio facta in judicio omni probatione majoris est, simply means that a confession made in a judicial proceeding is more powerful than any other proof. It directly captures the spirit and the purpose of Section 53.
Now, a question I often get from aspirants is about the relationship between these new laws and the old ones. So let's quickly compare Section 53 of the BSA with its counterpart in the old Indian Evidence Act.
This provision used to be Section 58 of the Indian Evidence Act of 1872. The new Bharatiya Sakshya Adhiniyam 2023 has placed this exact same provision under Section 53. So the crucial takeaway here is this: there has been no substantive change to the law. The principle is exactly the same, only the section number has been updated. This is done to ensure legal continuity. All right, let's bring it all home and focus on what matters most to you: doing well in your exams. How should you be preparing this section for your Judiciary or APO exams? Let's get into some specific, actionable advice. For your Judiciary prelims, you should expect direct, section-based questions. For example, they might ask which section deals with the principle that facts admitted need not be proved. The answer, of course, is Section 53. For your mains exams, you need to be ready for problem-based questions. You'll be given a factual scenario, just like the contract dispute we discussed, and you'll have to apply this section. And here's a pro tip: always remember that part about the court's discretion. This is a favorite area for examiners to create tricky questions. So, for a quick revision, just lock in these 3 key points. First, the section number is 53 of the Bharatiya Sakshya Adhiniyam. Second, the core concept is that admitted facts don't need proof. And third, its importance for both your prelims and mains exams is very, very high. Keeping these in mind will really help you. And that's our comprehensive look at Section 53. I really hope this analysis has been helpful for your preparation. For more legal content focused on judiciary, APO, and other law exams, make sure you stay connected with Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.